Hi, my name is Megan Gamble. I'm with the California Restaurant Association, and this is Ask CRA on the Confidential Bulletin. Today, I am joined by Vance Piggott. He is our legal partner. He's a shareholder at Chronic, which is a law firm here in Sacramento. And I just thank you so much for joining me today. We're going to do a brief Ask CRA on the love of everybody's life, which is Prop 65. So I'll just start it off and kick it off to you. Can you give us a little rundown of what Prop 65 is and why restaurants should be concerned?
Yeah, so Prop 65, it's not a new law, but it's kind of one of these ever-evolving and expanding laws that the state loves so much. So it's known as the Safe Drinking Water and Toxic Enforcement Act. Interesting thing about Prop 65 is it actually doesn't prohibit toxic substances. Really, what it requires is that you warn people about possible exposure to toxic substances. So when we're going through all of this, you'll notice that we're talking only about warnings and what you have to warn people about, as opposed to telling you that you're not able to use certain products or certain chemicals.
Got it. Thank you for that. So there's no, I mean, okay, I don't know as much about Prop 65 as most of our restaurant operators do, but my understanding is when I walk into a restaurant and I see on the wall, this building may contain, chemicals known to the state of California, blah, blah, blah. Is there like a one sign fits all? Like, how does that work? Do you have to have different signs?
Yeah. So there is one sign, at least one sign, that all restaurants are going to need. Any restaurant is supposed to have up a sign that warns about, and I always get in trouble when I try and pronounce the chemicals, acrylamide. Does that sound right, Megan? No?
I mean, yes, because
Okay.
I have no idea.
So there's a couple different substances that come from grilling meats or from using certain pans or cleaning products, whatever the case may be. But the law actually does provide for some what they call safe harbor language. So the law in general only requires a clear and reasonable sign which warns people about possible exposure. That's not all that good of guidance to say you have to have a clear and reasonable sign. They do provide what's called safe harbor language. And that's what you will generally see. You kind of see that same exact language. CRA actually has those signs available on its websites for its members so that you can just purchase those, put them up. So that one warning sign will cover you for food and non-alcoholic beverages. Okay. Non-alcoholic beverages, but of course, a lot of restaurants also serve alcoholic beverages. So I hear. There is an additional sign that's required if you serve alcoholic beverages because the risks of exposure are different for those alcoholic beverages and the non-alcoholic beverages. CRA also has a sign which contains the safe harbor language for that alcohol warning that has to be posted.
Well, thank you. So we've been hearing, or even I have been hearing from membership. Mostly it started, I feel like, in San Diego and some of the coastal areas and has grown a lot. So I actually heard from some of our Sacramento chapter folks. Basically, we've been seeing a lot of restaurants that felt that they have had these things covered with their signage have been getting new claims filed recently under Prop 65 for chemicals called phenols. And a lot of that can be, I think it's BPS and BPA that are in a lot of times thermal paper. They can be in stickers. Those chemicals are it's a big family of chemicals and they are in quite a bit of things. So I wanted to, part of this, the reason we wanted to do this Ask CRA was to kind of explain what restaurants are seeing from your perspective and how they can protect themselves.
Yeah, absolutely. A new iteration. Like I said, this is kind of one of those ever expanding laws here in California. So earlier this year, the administrative body that oversees Prop 65 added a new chemical to the list of chemicals which you must warn consumers about. So you mentioned BPA and BPS. BPA was actually covered under that restaurant food warning that we had, but they added BPS, which is despite just one letter being different, is a completely different chemical and triggers a completely different obligation on behalf of restaurants and really any places. I've seen those claims be filed against 7-Elevens and grocery stores, restaurants. They are popping up everywhere because it's a new chemical listed. A lot of people were kind of caught off guard by this. So that BPS is one of those chemicals, like you mentioned, that is present most relevant to restaurant clients. I'm seeing it in that thermal receipt paper. To what extent it's actually in that thermal receipt paper and whether it actually rises to the levels, who actually knows? I have no idea. But it's at least enough that these law firms that go around trying to drum up Prop 65 issues can put on a piece of paper and file a complaint with a straight face, I guess, that you are exposing individuals to BPS without the proper notifications. So, like I mentioned, because it's a different chemical, because it's different risk, there's a different obligation to provide a warning. So now on top of those two warnings that we already talked about, the food and non-alcoholic beverage, the alcoholic beverage, now you have a new one if you use any products which contain this BPS. And again, it is typically paper products. I know part of it is stickers, adhesives, shipping labels. I know has been one thing where it's brought up to, but again, we see it most with that thermal paper. And again, the requirement is only that you provide a clear and reasonable warning. So what my office did is we worked with CRA to put together some language, which we believe is a clear warning about possible exposure to BPS. By no means do you have to use that specific language. We think it does cover probably most of the issues that you might see. I have seen some people want to make really clear that the BPS is only in paper products. They don't want individuals thinking that food contains this separate chemical which can cause problems. So, what warning is appropriate for you will really depend on the circumstances. But like I said, CRA will at least have some language which should cover most potential uses of BPS.
That's awesome. Thank you for doing that. So, for those of you that don't know, we do have a store. So, that signage that Vance you're talking about, we do have. It's available for members. You can get it online in our store. So, you can download and print it to protect yourself right away. But we also really do recommend that you reach out to our legal center helpline. At least you can make sure you connect with one of our legal center partners like Vance to double check what you have in your restaurant, what paper you're using, and what language makes the most sense for your specific restaurant or space. So, Vance, I just want to thank you so much for taking the time to educate our members. We also have a legal insight that you helped update on that front, which, if folks want to do a deeper dive into the how it's covered, we do recommend that as well. And thank you for that signage language for our members. It's super important. And I mean, from what I hear, the claim filings are pretty expensive. So.
Okay, great.
For CRA members, if you would like to find out information about the Prop 65 signage, you can go to calrest.org/store. That is where you'll find the sign. And to connect with our helpline, I highly recommend that you just go ahead and email helpline@calrest.org. Thank you for joining the Confidential Bulletin.